If you've been following the whispers surrounding the It Ends With Us production, you know that things have been messy. But yesterday, the mess got 152 pages of legal jargon serious. A massive motion for summary judgment order just dropped, and it has sent shockwaves through the legal community and the entertainment world alike. From dismissed claims to accidental waivers, this order changes everything we thought we knew about the upcoming trial. While some doors just slammed shut for Lively, a few windows of opportunity just flew wide open. Before we get to the retaliation drama, we have to talk about the big loss that everyone is buzzing about. Do you know which major claim just got tossed out of court? In any legal drama, there is usually a headline claim, the one that grabs the most attention and carries the heaviest emotional weight. For Blake Lively, that was the allegation of sexual harassment. However, in a move that felt like a cold splash of water, the judge officially dismissed these claims. In legal terms, the court found that the evidence provided didn't meet the strict threshold required to move forward to a jury. When a claim like this is dismissed, the narrative shifts. Instead of the conversation being about what happened to her, the legal implication starts to lean toward, did you actually harm your own reputation? It's a tough pill to swallow when a judge essentially says, this part of your story doesn't have the legs to stand on in my courtroom. If the harassment claims are gone, does that mean Wayfarer is off the hook? Not even close. In fact, the judge left behind a triable issue that might be even more dangerous for the studio. Do you think a jury will see revenge where the judge saw dispute? While the harassment claims were tossed, the retaliation claims survived. The judge didn't say retaliation definitely happened, but he also didn't say it didn't. Instead, he ruled that there are triable issues of fact. This is where the storytelling gets interesting. The court looked at the mountain of evidence, the text messages, the expert reports, and the media strategy notes, and basically threw his hands up and said, it could go either way. When a judge says a case could go either way, it becomes a battle of likability and believability. A jury doesn't just look at the law, they look at the people. They look at the text messages sent at 2 a.m. They look at the protected activity lists. The 17-point list. One of the most fascinating pieces of evidence mentioned is a 17-point list of protected activities from 2023. This is essentially a paper trail of every time Lively claimed she was being treated unfairly. The retaliation claim is the survivor of this order, but there was a massive mistake made by the Wayfarer legal team that might haunt them. Would you believe that a simple oof in paperwork could change the outcome of a multi-million-dollar case? Lawyers are human too, and sometimes, even the most expensive legal teams miss a spot. In this 152-page order, a glaring procedural came to light. The attorneys noted that Wayfarer failed to bring up a specific defense called the exhaustion of administrative remedies. In plain English, usually before you sue someone for certain workplace issues, you have to go through specific government channels first, like the EEOC. If you don't, the defense can usually get the case thrown out on a technicality. If the defense doesn't mention it, they lose the right to use it. The judge basically said, you didn't argue it, so it's waived. It's gone. This means certain retaliation claims that should have been dead on arrival are now alive and well, simply because a box wasn't checked. It's the legal equivalent of forgetting to lock your front door and then being surprised when someone walks in. This waiver keeps Lively in the game. It's a reminder that in the legal world, how you play the game is often just as important as the facts you have. So, Lively has a foot in the door, and Wayfarer is on the defensive. But can Lively just change her mind and walk away if the heat gets too high? You might be surprised by how trapped both sides actually are. A common question in the comments of the video was, can Blake just drop the remaining claims and move on? The answer, according to the legal experts, is a resounding no. Once you get this far into the legal process, especially after a motion for summary judgment, you can't just unring the bell. To drop the claims, Lively would need the consent and approval of the defendants, Wayfarer. And why would they give it? At this point, both sides have spent millions. Both sides have had their dirty laundry aired in 152-page public documents. Wayfarer likely wants a total, not guilty, verdict to clear their name, and Lively wants a win to justify the battle. The settlement leverage, The only exit is a settlement. But with the harassment claims gone, Lively has less leverage than she did a month ago. The appeal trap. Even if the trial ends, the drama doesn't. The attorneys discussed how an appeal can add years to a case. Imagine living under the shadow of a lawsuit for another 3 to 5 years. It's a grueling, exhausting process that takes years off your life. As one of the attorneys put it, it's not just a battle of money, it's a battle of endurance. But there is one more person lurking in the shadows of this case. A name that keeps popping up in the documents. Do you know who Jones is and why they might be the one to finally break this case wide open? As we look toward the trial, the landscape has been cleared of the noise and narrowed down to the fire. The sexual harassment claims are in the rearview mirror, but the retaliation battle is looming like a thunderstorm on the horizon. Now that the sexual harassment claims have been dismissed, do you think Blake Lively still has a strong chance of winning on retaliation? Or has the heart of her case been taken away? Share your thoughts in the comments below.